employers should know that despite best efforts and having a stellar safety program, accidents do happen. And so that's when workers will file workers' compensation claims. And some of them are very tough, right? And so I just wanted to briefly go through some of the key topics that I've seen questions arise in is how do we support an allowance protest? What happens if my worker continually is seeking treatment? And how do we terminate time loss? So, if you're a state fund employer, your worker will fill out a report of accident, or if you're self insured, a SIP 2. As an employer, you have the opportunity to respond. If there's enough red flags and you have enough information, you can request that the department deny the claim altogether. For most employers, you need time to gather information. So, an option is to also ask the department for what's called an interlocutory order, saying, look, hold your decision in regards to acceptance until we have time to fact find. And the department will either grant the interlocutory order or they may just issue an order allowing the claim. So, if the department issues an order allowing the claim, you have 60 days to protest. And so, this is the time that you want to use to preserve and confirm information and note facts that you may be able to obtain in order to support your protest. So, just a really quick review when we're talking about allowance issues. So, they fall into an industrial injury, which is a tangible happening. It came at a discrete time, and there's medical diagnosis by, attending or ER physician, right? This is the typical, I picked up a box and now I have a disc protrusion. Occupational disease, on the other hand, is a condition that rose naturally and proximately out of the specific work duties, so not out of daily living. Again, supported by medical diagnosis, but this is more of your COVID exposure or bilateral carpal tunnel syndrome. So during your allowance investigation, you want to confirm that you have a claimant statement. Some employers have a third party conduct an interview on their behalf, or if you have somebody in your organization that does so, you want to have a clear understanding of the mechanism of injury, right? We want to lock down exactly how they were injured. We want to look at the medical records and see what is the condition that they are complaining of that's diagnosed. Is this a degenerative disc disease, or do they just have a sprain? Could it be that this was a condition that they had prior? And a key thing is to also correlate with the schedule. So if the claimant is saying, I got injured on a Friday the 15th, but you look at your calendar and that was a Saturday or Sunday, then there's some digging and some correlating we need to do to clarify the timeline. Going back to the medical issue, so for some workers, there are red flags, either from statements from coworkers that maybe they have a condition that they've been complaining about and they were intending to get surgery. So some employers are very proactive, and during this time, they'll actually request a medical canvas. And so this allows us to identify medical facilities that a worker has been treating at, and then we request those medical records to see if they were symptomatic. And what does symptomatic mean, and why does it matter? And so it's because if we can show that a worker was complaining of their back and lumbar issue a year prior, a month prior, just a week prior, days prior to the quote unquote injury day, then we're showing that that injury didn't really cause the condition that they're complaining of. Pictures. So if the pictures can actually also help down the line to assist a trier of fact, experts, and vocational witnesses. I had a claim where a worker was asserting that a degenerative knee condition was caused by lifting 1,000-pound marble slabs. And of course, you look at that and say, well, anybody would be injured. But we were able to get pictures, and my vocational expert was able to demonstrate that a worker could actually lift these 1,000-pound slabs with just a few fingers. And that's because there were a lot of mechanisms in place and machinery. So the worker was not solely responsible for lifting these slabs of marbles by themselves. Employer statements. So whether from management or coworkers that observe kind of physical ailments before, or even outside activities. I had another claim where I had a worker, it was a lower extremity complaints in a knee, and then the coworker was told us that, hey, we believe he does MMA fighting underground. Lo and behold, we're able to find videos on YouTube because he was so proud. So it's this garage underground MMA fighting. So that was wonderful. So, getting those statements, talking to coworkers, and then preserving the contact information. And so I'm just going to briefly go through, since I'm running short on time, but continued treatment. So, why do we care about continued treatment? That's because in order to close down an allowed claim, we need to find that the employee is medically fit and stable and they're employable. And so, if you have a worker that is consistently getting chiropractic or massage therapy, and their attending seems like they're always recommending new MRIs and x rays to find new conditions to treat for, it can lengthen the claim and cost you more. And so, I like to refer employers to look at the department's own treatment guidelines and the HTCC, which gives considerable weight. And what this can do, for example, for acupuncture, some attendings like to recommend acupuncture, but if you look at the department guidelines, that is only for a specific condition in the spine. It's not for the entire spine. So when you see those authorizations or requests for authorizations, you can put in your voice as the employer to say, no, department, look at your own guidelines, look at the HTCC to protest and address those. Reconcile the area of expertise. I've had a chiropractor basically recommend and diagnose neurological symptoms. And so we've alerted the department to that, which goes far. And claim investment, sometimes you may also want to spend a little bit to have a forensic opinion or to conduct surveillance of your worker to show maybe their physical abilities are more than what they're telling their attending physician. And finally, terminating time loss. Really, this could be a presentation all on its own. And actually, it was. I had the wonderful opportunity to present with Brittany Pierce just last week about the concerns and risks with terminating an injured worker. So if you're interested in that, let me know and I'd be happy to send you a link to that presentation. But just really briefly, again, terminating time loss, here's a list of the things that you essentially need to do in order to terminate time loss. Light duty is always a great option for employers to address and mitigate the cost. And if you can't terminate the time loss, doing your due diligence and communicating with the worker, the attending, can help with any vocational assessments or litigation down the line.